Next, we'll hear from Stephen Halbrook, an author and gun rights attorney who has successfully argued 3 gun law cases before the Supreme Court. He talked about the Second Amendment and gun laws at the Long Island Federalist Society in April. This is about an hour and 15 minutes.
Could I ask for everyone's attention? Thank you so much. Thank you. Thank you. For those of you who are here for the first time, I'd like to introduce myself. My name is Frank Amendolia. I am the president of the Long Island Lawyers Chapter of the Federalist Society for Law and Public Policy. The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. The Society seeks both to promote an awareness of these principles and to further their application through its activities. I am very excited to present to you our speaker this evening. Stephen P. Halbrook is a senior fellow at the Independent Institute. He has taught legal and political philosophy at George Mason University, Howard University, and Tuskegee Institute, and he received his J.D. from the Georgetown University Law Center and Ph.D. in social philosophy from Florida State University. The winner of 3 cases before the U.S. Supreme Court, he has testified before the Subcommittee on the Constitution of the Senate Judiciary Committee, Senate Subcommittee on the Constitution, Subcommittee on Crime of the House Judiciary Committee, Senate Governmental Affairs Committee, and House Committee on the District of Columbia. A contributor to numerous scholarly volumes, he is the author of the books Gun Control in the Third Reich, Disarming the Jews and Enemies of the State, The Founders' Second Amendment, That Every Man Be Armed, Securing Civil Rights, Freedmen, the 14th Amendment and the Right to Bear Arms, and Target Switzerland, Swiss Armed Neutrality in World War II. He is also the author of the forthcoming title, Gun Control in Nazi-Occupied France, which will be available beginning next month on Amazon.com and through other booksellers. It's with great pride that I present to you Stephen P. Halbrook.
Thank you, Frank. It's a real pleasure to be here. This is kind of a deja vu thing. I spoke here in the early 90s. I think the title of my address tonight is supposed to be Assault Weapons or Assault on the Constitution. Well, that's a big issue now. It was also a big issue in the early 90s. California became the first state nationwide to ban any kind of rifle. Before the so-called assault weapon mania started, rifles were considered good, handguns were considered bad. In New York State, there's a lot of judicial decisions talking about how great rifles are. Not so much handguns. You've got the Sullivan Law and other laws like that. They were very restrictive about handguns, but up until that point, rifles were considered really good. So in the early 90s, New York City enacted a so-called assault weapon ban, and we litigated that in a case called Richmond Borough Gun Club versus, I think, Dinkins. See the mayor then? Yeah, okay. I'm getting old, but I remember took a few things out. So, yeah. So they banned rifles that had a magazine more than 5 rounds, things like that. And that's when I spoke to this group earlier. You know, it's been 20 years ago, I guess, or more. But it was a pleasure to be here then, and thank you for having me this time. So what's the definition of assault weapon? Well, there's something in Alice in Wonderland which somebody says it's, what do you want a word to mean? It means anything you want it to mean. And if you go back, I'm an attorney, so I look at a lot of judicial decisions, and if you go back, universally the term assault weapon means, what would you guess? A weapon used in an assault, maybe? You'll find cases where there's a reference to the prisoner struck the guard using as an assault weapon a broom. So generically, I mean, that's plain English, isn't it? The term assault rifle was invented by Nazi Germany, and when they came out with a selective fire rifle that would fire fully automatic and semi-automatically, and they called it the Sturmgewehr or storm rifle, which the English language people call assault rifle. And that came to mean and refer to the AK-47 developed by Kalashnikov in Russia. And with all of these types of military equipment, full auto means that if you pull the trigger, it empties the magazine. It continues to fire more than one shot by a single pull of the trigger automatically. And it just goes on and on like that until you have no more ammo. Whereas semi-automatic means a firearm that you have to pull the trigger for every shot. So the way the propaganda term came in was when the first groups that wanted to ban rifles started dealing with that issue as opposed to handguns, which was their traditional issue. They said, why don't we call them assault weapons, these semi-automatic rifles that we want to ban? And that's confusing to the public, and it's very favorable for us because they makes them think that these are machine guns that we're talking about. And so we end up with first California and then New York State. There was a federal law on so-called assault weapons that lasted for 10 years, and it sunsetted. There was a study done, and it showed that it had no beneficial purpose. Such bans exist in Connecticut and Maryland. Most states don't ban ordinary rifles of this type because they're very ordinary. If you go to any shooting range in the country, you'll see so-called AR-15 rifles, which are nothing but semi-automatic rifles that fire one shot per trigger pull. In fact, that's the most popular firearm, most popular rifle today in the U.S. So none of these entities that ban these kinds of rifles, and I'm using the term rifle because that's mostly what's banned. It's mostly not handguns or shotguns. They say it's a semi-automatic rifle that has a detachable magazine, but that's not enough. None of them are banned just because of that. They go on and have a list of features that if the rifle has one or two of those features, then it's a banned assault weapon, and it's a felony to possess it, and so it's not something to play lightly with. To illustrate that the word means anything you want it to mean, the definitions are opposite from each other depending on where you go. So New York City, and then finally when New York State banned these rifles, if it's got the semi-automatic feature, detachable magazine, then it's not an assault weapon unless it has one of the features that's on the list. And one of their favorite features to list is a pistol grip that protrudes conspicuously beneath the action. So they didn't say a pistol grip that protrudes 6 inches and at a 45-degree angle or anything precise like that. It protrudes conspicuously. So that's it's like beauty. It's in the eye of the beholder whether it's conspicuous. But in any event, it's a pistol grip on a rifle. But if you go to the state of Maryland, which also has its so-called assault weapon ban, it does not include the protruding pistol grip. And if you think about this, you have all these exaggerations about how deadly something is and it's military and this and that. But sometimes, like Freud said, a cigar is just a cigar. Sometimes a semi-auto rifle is nothing but a semi-auto rifle. It can have a pistol grip that protrudes conspicuously, how horrible, and it's not going to be any more powerful or deadly than any other rifle. So Maryland doesn't have that feature. Under the New York definition, it's an assault weapon only if it has the pistol grip and a shoulder stock. But if you go to Chicagoland, Cook County, the county that encircles Chicago, they have a ban, and it's an assault weapon if it has the pistol grip but no shoulder stock. So these are opposite definitions. And so how can you tell me that one is deadly and the other one's not? One is so extraordinarily deadly that they have to be banned and they have to put people in prison for many years if they possess it. So the fact is, it's just an arbitrary designation. And so here in the state of New York, you can have a semi-auto rifle, but it can't have a protruding pistol grip. So you can go on the internet and Google AR-15 New York State law or something like that, and you'll see, okay, they took the pistol grip off, and you can legally sell a rifle in this state if it's got some other kind of very weird grip. It almost looks like plumbing pipe. It's exactly the same rifle, and it's really ugly too. So that's the way the manufacturers and the retailers get in compliance. This doesn't mean it's a loophole. It means they're getting in compliance with the law, but it's a very silly law. Another one of my favorite features that they really like to ban is what they call a telescoping shoulder stock. So how would you like to live in a society where all shoes were the same size? You know, the Soviet Union used to produce goods based on what bureaucrats would decide and not based on consumer demand. So yeah, you could get lots of shoes the same size, and they didn't really care if they fit the consumers. So there are rifles that have a shoulder stock where you can make it a little bit shorter or a little bit longer to fit your size, just like you would a shoe. And once again, that's another one of these listed features that makes it that you get a felony conviction and incarceration for if you have an adjustable shoulder stock on one of these rifles. So they say, well, that makes it more concealable. But all you have to say, if you don't want a rifle to be smaller than a certain length, you can just say that. You can say, okay, it's got to be 26 inches overall, which is the federal standard. And if the shoulder stock adjusts at its shortest, if it's 26 inches, it's not considered concealable. I mean, it could be as long as between these two walls, and it would be banned in New York as an assault weapon and concealable because it's got the shoulder stock can adjust 2 or 3 inches. So what does all this mean in the context of the Second Amendment? What's happening is that politicians want to say they're doing something. It's the same story. And why don't we say we're doing something about gun violence, and we're going to ignore that, well, some people didn't get prosecuted who should have been prosecuted. They should have been incarcerated. They should have been on the criminal background check list, and they weren't because some government official failed. You can go through one tragedy after another, and you'll see government failure. Parkland, Florida is a good example, or the Texas church shooting, one after another. So as a politician, why don't we make people think we're doing something? And why don't we say, for example, the dreaded pistol grip, the evil, wicked, mean, and nasty pistol grip? Why don't we ban that? And we say, how do we justify it? Well, how about it makes it where you can spray fire from the hip? That sounds really juicy. And so if you think about it, if you hold a rifle with a pistol grip like that from the hip, first of all, you're not going to hit anything. Secondly, it's more uncomfortable. If you have a traditional stock on the rifle, you can hold it more comfortably from the hip. But facts really don't matter, and they don't matter in this context because you'll have judicial decisions coming down and saying that the pistol grip's so deadly because you can shoot from the hip, but it's not even true, and there's not even any tragedy that's happened in that context. And in fact, you will find rifles with pistol grips in the Olympics. How many of you watched the biathlon events in Korea? All of those rifles had a pistol grip, and I think they had 5-shot magazines. But there's other Olympic disciplines that use air guns. They're not even firearms, and they're only single shots, and they have the same type of pistol grip. So once again, these are arbitrary characteristics. Let's move to the Second Amendment. There's a key word in it. The last word in the sentence is arms. Arms are weapons. That's what was meant to be protected. So the fact that something might fire a projectile and can be used as a weapon, hello, that's what the Second Amendment was meant to protect. Now, the text of the Second Amendment is a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. It's got two different thoughts, just like the First Amendment has about, I don't know, 5 or 6 different thoughts. The Fourth Amendment has 2. Be secure against unreasonable search and seizure, plus the warrant requirement. So it's not like because a constitutional guarantee has more than one thought, it doesn't mean that one thought overcomes another thought. And that's the case with the Second Amendment. You've got a well-regulated militia being considered necessary for a free state. That's an assumption that the founders made as a matter of political philosophy. And so what could encourage a militia of that type? It would be, why don't we recognize the right of the people to keep and bear arms and say that it shall not be infringed? The thought was that if you have an arms-bearing population, it would be easier to raise a militia as opposed to just having a standing army, which the founders were adverse to after the experience with the British Redcoats. So what happened over time, though, is back in the 1960s, we had a lot of violence in this country. The assassinations of the Kennedy brothers, Martin Luther King, and the riots, and all the disturbances because of the war, the Vietnam War, and all that. So Congress thought, why don't we make it a felony to do all kinds of things with guns, not to misuse guns, but just to create technical felonies like you can't buy a gun in another state, that's a felony, or there's just a whole lot of things they wanted to do, some of which they didn't get. So you have the passage in 1968 of the Federal Gun Control Act, and to justify it, many people started saying in the academic world and in the legal profession, well, there's really no right of the people to keep and bear arms. There's really only a power of the state to maintain militias. And that's all that is meant by the people doesn't really mean the people, and keep and bear doesn't mean keep and bear. It means that states can have militias, and the first clause of the Second Amendment overcomes the substantive right that comes after it. As a matter of fact, if you go back to the origins of the Second Amendment and the debates in Congress over the Bill of Rights before it was proposed to the states for enactment, the Bill of Rights was not part of the original Constitution. It was not adopted until 1791, and the Constitution was in 1789. But the right to keep and bear arms was not controversial. But it was controversial as to what power the states and the federal government would have over a militia. And the so-called anti-federalists wanted to have a provision that if the Congress didn't promote and maintain a militia, then the states could do that. And that was not put in the Second Amendment, but what it was put in was simply a political principle, kind of an admonition, without being a substantive right, that a regulated militia is something that a free state has. So there you have it. When the so-called collective rights view of the Second Amendment was invented in the 1960s, that doctrine was invented so that you could justify any kind of gun control scheme, whatever, any kind of prohibition. In other words, we're talking about denying there's any kind of individual right. Then you don't have to worry about the Second Amendment being an obstacle to gun control legislation that you want to pass. And what was really just frankly weird about that was what does the word people mean, and what is a right of the people? If you go to the First Amendment, you'll see reference to the right of the people peaceably to assemble. And you go to the Fourth Amendment, the right of the people to be secure in their persons, papers, houses, and effects from unreasonable searches and seizures. So, you know, when it comes to the Second Amendment, it's not a right of the people anymore, or it means something totally different. It means a power of the state to maintain militias. So it never was a credible doctrine, but it had a lot of sway. And so if we turn the clock up until 2008, this case lands on the Supreme Court docket called District of Columbia versus Heller, because the Supreme Court had never ruled definitively on the meaning of the Second Amendment. And so you have quite a case that drew much attention nationwide. And there were a number of so-called friend of the court or amicus curiae briefs filed. I had the honor to file a brief on behalf of a majority of members of the U.S. Senate and the U.S. House of Representatives. It was not a Republican brief, it was a bipartisan brief, and it argued that the Second Amendment does protect individual rights, and the District of Columbia handgun ban violates the Second Amendment. So in any case, that the Supreme Court took that case, and obviously nobody knew what the court was going to do. It was one of those cases that everybody worries about on both sides of the issue. And I don't know how many of you have ever been in the U.S. Supreme Court. It's quite a neat experience. If you ever go to D.C. and you want to stand in the line to go there, do it. Although most of the cases are pretty boring. But this case, there were people standing out, or actually got in the public line 24 hours ahead and just slept on the concrete. But they have a special lawyers section I got to sit in, and the other lawyers were all up there, and the case is being argued. And nobody knew where Justice Kennedy was going to come down on this, because everybody kind of figured you had 4 on one side and 4 on the other. And because he's the swing vote. I mean, he's well known for that in controversial cases. So, I don't know, halfway through the argument, Justice Kennedy's mouth starts to open, and everybody's hanging on the edge of their seats. And he asked the government lawyer, the lawyer for the District of Columbia, well, so weren't the colonists, the settlers, the founders of this country, didn't they need guns to protect themselves from criminals and Indians and grizzly bears? So we'll forgive him for thinking there were grizzly bears east of the Mississippi. That obviously indicated an individual rights interpretation. And of course, you never know for sure when you argue a case there or you observe cases there, how they're going to come down based on things they might say, but at least it gave a hint. And so the last day of the session, as it always goes, the most controversial cases are decided the last day of the session, late June, and the Chief Justice will say who will read a summary of a specific decision. There were 2 cases on the docket that way. Summaries were going to be read. In the first case, the Chief Justice said, Justice Stevens will summarize the decision of the court. So, okay, that means we lost, if that was the same case. It turned out not to be, because then he said, after that was finished, Justice Scalia will summarize the decision of the court. And so, as you would guess, it was 5-4. Kennedy went the right way. And the District of Columbia was very defiant. They went out on the steps in front of the Supreme Court and said, we're going to make it harder for gun owners than ever before. And they did exactly that. They made it, all guns have to be registered in the District of Columbia, and they were going to cancel your registration every 3 years. And if you didn't renew it, then you were in criminal violation of the law. And they imposed a lot of other requirements, which I and another, we had a team that we litigated those requirements, and we won some of that and lost some of it. But in any event, that's the way the court ruled. It's an individual right. It says the people keep and bear arms. It's not confined to the militia. There were 4 justices dissented, but there were 2 dissenting opinions. One was by Justice Stevens. Y'all heard about recently he wants to repeal the Second Amendment? Okay, that's because he didn't get his way when the court ruled in the Heller case. Justice Stevens said the Second Amendment right of the people to keep and bear arms means that you have an individual right to bear arms in the militia. Okay, let's say that again. I mean, of course it doesn't say that. And do you have a right to be in a militia?
No.
You have a right to do what you want to do if you're in any kind of military force. Nope. So that was more or less contrived. And it didn't win the day, but obviously it was close. It was 5-4. And Justice Breyer had a balancing test that he wanted to hold in the case, where whatever the legislature did, if it's gun control, that you uphold anything they do, because they're more able to understand what's constitutional and what's not. Like, really? I mean, legislatures, and do you say that on other issues, of other types? No. So the day after that decision came down, the District of Columbia is a federal jurisdiction, and therefore the Second Amendment applies there. But then the next question was, does the Second Amendment apply to the states? By the way, I've done some other litigation in this state. These travelers from other places, they don't understand. They come in, they're making a connecting flight, or maybe they're coming in from Philadelphia or wherever, and they're checking their bags at LaGuardia or JFK, and they follow the TSA requirements that I'm declaring that there's an unloaded firearm in my baggage. And we have interstate transportation of firearms by airlines every day and all over the country. And there's a federal law saying that's legal, and that even if you have a state law against gun ownership in that state, like handguns are banned to out-of-state people in this state and you can't get a license, that the federal law says you can transit that state and they cannot arrest you. So what happens is I had a client who was a lawyer from Florida, and he was making a transit through, I forgot, JFK or LaGuardia, and so he declared his gun, and so they called the police. And this has happened to many hundreds of people. Called the police, and the TSA guy defends the lawyer, and he says to the cop, like, well, this is federal law. He followed their requirements. He declared his gun. And the New York cop said, hey, this is New York. Federal law doesn't apply here. So you all know what I'm talking about. So in any event, the question was whether the Bill of Rights, and specifically the Second Amendment, applies to states. Because many states with very strict gun laws have always argued before these cases that the Second Amendment doesn't apply here. That's what the district argued, even though the district's not a state. So the only other handgun bans in the United States at that time were in what I call Chicagoland. That would be Cook County, Chicago, Morton Grove, all those little jurisdictions around the Chicago area. That it was a fad to ban handguns back in the 80s, and so they passed these laws. And so right after the Supreme Court ruled in Heller that a handgun ban violates the Second Amendment, lawsuits were filed against those jurisdictions to invalidate those laws. And again, those cases all worked their way up to the Supreme Court. And in a case called McDonald versus Chicago, the pro-Second Amendment side prevailed, and the Supreme Court held the right to keep and bear arms is a fundamental right. It's accorded to all law-abiding citizens, and it's something that no state can violate. And so all of those laws went by the wayside. But other than one case that's a little more minor, there was, I'll just mention now, there was one other Supreme Court case that nobody saw coming. There's a few states, probably, I don't know whether New York bans stun guns or not, but Massachusetts does ban mere possession. And there was a woman who had been beaten up by her boyfriend. She had restraining orders, and he was threatening her, and so she carried a stun gun to protect herself, and she was caught with it by the police, and they busted her. And that case went all the way up to Massachusetts' highest court, and the court upheld the ban on stun guns and said that the Second Amendment does not protect it. The case went to the Supreme Court, and they said, you know, you really did a sloppy decision, and you upheld this law on grounds that we did not say were the correct way to reason this, and we're going to remand the case back And anyway, the case is called Catano versus Massachusetts, and the Supreme Court in the United States basically said that based on our prior rulings, it would seem that stun guns are protected by the Second Amendment. So that's the last word by the Supreme Court. It's not heard any other cases, but a lot of the lower federal courts have been in rebellion against the Supreme Court, and there's been several instances of litigation brought where the lower federal courts uphold these bans on so-called assault weapons. So getting back to that subject, the states, after the Sandy Hook tragedy, massacre, you had New York and Connecticut very quickly enacting legislation. I think in New York it was like the massacre took place maybe about 2 days later. It was waiting in the wings. There was this massive new law called the SAFE Act that was actually enacted and signed by the governor with no committee hearing, without any kind of real debate. It was a law that was already drafted, I guess, waiting for the right tragedy to take advantage of. And so it passed, and it had some weird things in it. What's incredible is that New York used to have two different features that a gun had to have to be considered an assault weapon. So you start out with, it's not good enough that it's a semi-automatic rifle that has a detachable magazine. It's got to have two other features. And so overnight, when that law was signed, what was an assault weapon yesterday, well, there was a lot more stuff that was an assault weapon the next day when that law was signed, which again shows you the arbitrariness of these definitions. So it was changed to just having one feature. And those features are types of features that I described earlier that have no effect whatever on the power of the gun. It also banned magazines, magazines that hold cartridges that hold more than 7 rounds. Not realizing that hardly any guns have magazines that hold 7 rounds. They're just not available. And the cool part is they forgot to exempt law enforcement officers. So, go figure. That's what happens when you enact something overnight like that without any consideration about anything. So they went back and did some amendments to the law so that it would exempt law enforcement officers. And but it also did they also did something else. After the governor found out that there aren't magazines that are just 7 rounds available for virtually any guns, that would mean you would be basically banning most guns because they don't have 7-round magazines that come with them. So you wouldn't be able to buy any new guns except for some small number that happens to have 7 rounds. And so they amended the law to say, because there are a lot of guns that you can get 10-round magazines for. So they amended the law to say, okay, 10-round magazines are the limit, but guess how many rounds you can put in it? 7. See, you've all done your math. Unless you're at a metallic silhouette competition or at a shooting range, you can have 10 rounds in it, but not if you're at home and you keep a gun for self-defense. You can only have 7 rounds in it. And so I was part of the litigation team challenging that law, and we were arguing that, first of all, the 10-round limit is arbitrary. Standard magazines, as we call them, for handguns, they mostly have anywhere between 10 and 17 rounds that they hold. And for rifles, standard magazines for semi-auto rifles are between 20 and 30 because they're used in target matches, and people keep them also for self-protection, and you want to have enough rounds in it to do the job if you have an emergency. And so, what the legislature ended up doing was to, as I say, making the 10-round limit. 10 rounds is is just as arbitrary as 7 rounds, especially when we look at what's the national norm. One of the holdings of the Heller case in the Supreme Court was that the types of firearms that are in common use by law-abiding citizens for lawful purposes are protected by the Second Amendment. And you can't just say that, well, anybody who would want one of these, what we're going to call assault weapons, must be a criminal. Every single firearm, when it's first sold at retail in this country, has to go through a federally licensed gun dealer, and there has to be a background check. Everybody who's ever been cleared for any purchase of any firearm goes through a background check. Many states also have background checks for private sales. So it's not really realistic to try to argue that, well, anybody who would buy one of those is some kind of criminal or has criminal intent. And specifically, when you look at, there's been use of some of these rifles in horrible tragedies, but if you look at the actual data, the number of murders in this country, they don't even compare. The number actually of rifle murders is very, very low. Handguns account for most murders because they're concealable. So we end up, though, with litigating these issues of, how many rounds can a magazine have, and the separate issue of, well, can you just make a list of guns that you're going to ban by name or by these features, and does that really have any leeway in terms of why is that not protected by the Second Amendment, the rifles that you're banning? And so we get all the way to the Court of Appeal. Actually, we started in the District Court for the Northern District of New York, and we had a Judge Scretany, who invalidated the 7-round limit. He said, it was like, you got to be kidding. You expect law-abiding citizens to only put 7 rounds in a magazine for home protection, and you're going to expect criminals to just have the 10-round magazines, and they're going to only put 7 rounds in it. So we argued that why would you expect criminals to limit themselves to 10-round magazines? And, why is 10 not an arbitrary number, just like the others? When the Supreme Court said the guns that are in common use by law-abiding people, they're preferred by American citizens, those are the ones protected by the Second Amendment. How do you get around that? And so some of the lower courts have just invented doctrines. They call it intermediate scrutiny, and they basically kind of do a balance, and they say, well, on balance, the government wins and you lose, and there's a basis for these guns being banned, and but they can't articulate, what the basis is for banning these features that are banned, like the horrible protruding pistol grip and the adjustable shoulder stock. How can you justify? So the courts spend very, very little time on those issues. But District Judge Scretany did invalidate 3 provisions as vague. The legislature couldn't describe what they were criminalizing. One of those was, well, if one gun is somehow related to some other kind of gun, then it's banned. And it's like a feature of other stuff like that. You might as well say other stuff like that in the law. And so he said, no, that's not good enough. But then my favorite one was a rifle with a muzzle brake is banned, B-R-E-A-K, muzzle brake, B-R-E-A-K. And so he said, I don't know how much English you people in the legislature had going to school, but if you wanted to ban a muzzle, B-R-A-K-E, you needed to say so. And you haven't done that, so he threw that part out. And but we get to the Second Circuit Court of Appeals, the fancy 3 judges in Manhattan, and that's good enough for the legislature. They can say B-R-E-A-K, and you're supposed to know what they mean, and it's like whatever. We're going to uphold that part of the law. And actually, the court upheld everything else except for that 7-round magazine. That just doesn't pass the straight face test, does it? That you can only have 7 rounds in a 10-round magazine. It's like, you're going to expect criminals to do that? No. But once again, the fallacy in what the court did was, and you're also going to expect criminals to go by the 10-round limit. Why would they go by that law when they don't go against, when they violate the law against home intrusion or burglary or robbery or whatever else? I mean, that's the problem with all these gun control schemes, is that if you're just restricting the type of metal that it is and bringing everybody under the law and criminalizing everything just because of some feature, it totally ignores that we need to focus on criminal intent and criminal actions, putting people away who actually hurt people, who commit robbery and murder and rape and whatnot. So that's really the whole focus in the so-called gun control controversy. And once again, just like with the word assault weapon, you have a lot of essentially propagandistic terms that are used in this debate. So it used to be gun control. That term was the standard term by persons who supported gun control, although others, people who are into competitive shooting, say gun control means keeping the sights aligned properly. But the word gun control doesn't resonate too well in the public mind. So now the term that's being used to ban guns and to put you in prison for having certain kinds of guns is the term gun safety, or better yet, common sense gun safety. And it has nothing to do with gun safety. It has to do with incarceration of otherwise law-abiding people for doing things that are completely victimless crimes. So, like was announced at the beginning, I have a new book that's just coming out called Gun Control in Nazi-Occupied France. So I'm thinking that was an improper title. You know, it has to do with the fact that France had gun registration. When the Nazis came, they put up posters, and I have copies of these posters as illustrations in my book. Turn in your guns in 24 hours or we execute you. And in 1940, when France fell, the French police went to work for the Germans, the occupying force. So what better gun control scheme could you have? You got the guns registered, you got the threat of the death penalty, and you've got the records, and you've got the same people who had the records before the occupation doing the bidding of the German army. And so, but I should have named the book Common Sense Gun Safety in Nazi-Occupied France. Thank you. That I should have named it that. I mean, that you proved it. And what turned out to be the case was that there were a lot of French people who were executed for having guns. We went through newspapers of the occupation period, and they would announce the name of the person and say why he was executed. You know, there were a lot of other things they were shooting him for as well. But having a gun and not turning it in, that was a no-no. One thing about these posters about turning in your guns in 24 hours, none of them put like what the date when the clock started ticking or the time it started clicking. I'm serious. There's one of them, the Museum of the Resistance in Paris, and it's just plain. And every other one that I've seen is plain. They don't say when you start. But despite all that, there were a lot of French people who didn't register their guns to start with. And how do you think they were able to form a resistance when that started? It's because they buried their guns, they hid their guns, and they got them back, and they were able at some point to start resistance activities. And these are the kinds of history lessons that we lose sight of, that you know, the current reaction to these tragedies, they completely lose sight of the fact that we have a Second Amendment for a reason. Our founders put it in because of their experiences with the British, because the British were trying to disarm the colonists in order to impose their otherwise oppressive measures of taxation and whatnot. But we've seen in the 20th century so many tragedies where these gun control schemes have led to horrible, disastrous results, which is one reason why we don't have registration of guns at the federal level, because people saw what happened in Nazi Germany and in the Soviet Union. So this is a controversial topic. You can pick any tragedy and pick it apart and talk about different things. I mean, Parkland, Florida, all the animosity in the media and otherwise has been against the NRA. And there was no demonstration at the steps of the FBI building. Nobody was demonstrating at Sheriff Israel's headquarters. Nobody was talking about social services department that hadn't committed this guy mentally, even though they recommended doing it. And nobody's talking about the cop that just stood out there while these kids were shot. So anyway, I hope that this historical background will come to light more, and that people realize the Second Amendment is there for a reason, and you don't get rights back that you lose. So I think with that, we've got just about 17 minutes or so left, and why don't we open it up, and do you want to moderate this, or
For those who are interested, we still have 3 copies left, only 3 copies left of Professor Halbrook's book, Gun Control in the Third Reich. You can get it at the back table. We're going to do this as expeditiously as possible, and I find that the best way to do it is by table. So we'll start with this table here in the corner. If anyone here has a question.
Of the things that you've described as criteria for an assault weapon, has caliber ever been in the issue? The caliber of the weapon?
By and large, caliber has not been an issue, other than in California law, it has to be center fire, it cannot be rim fire. So California doesn't ban firearms if they're 22 rimfire, which is a very minor caliber. All the other states with so-called assault weapon bans do ban them nonetheless, even if it's 22 rimfire, including New York. And the magazines that hold more than 10 rounds are banned as well, regardless of caliber.
In New York State, the way that the government and the statutes circumvent the Second Amendment incorporation into the 14th Amendment is by the presumption in our law, in our criminal law, that the possession of a weapon by a person who doesn't have a license is per se a presumption of intent to use unlawfully against another. What is your opinion of that presumption vis-a-vis the Second Amendment and its usurpation of the Second Amendment by that method?
Well, it's kind of a weird constitutional right that it's a crime to exercise that right unless you have a license. And in fact, there's a quote from, I think a New York State decision and U.S. Court of Appeals for the Second Circuit that it just says simply, in New York it's a crime to possess a firearm. Now, firearm is defined as handgun in New York, and it's only what's called a defense to that if you have the license. So I just think it's a shoddy way to deal with a constitutional right. You wouldn't say you have to have a license to engage in free speech, or to, I mean, maybe to do a demonstration in public, but and people also pretty much agree you might. It's legitimate for a state to require a license to carry a concealed weapon, but just to keep a gun at home and to require a license for that, it's like you got to get a license so they don't commit unreasonable searches and seizures or any other topic. So it's something that really demeans what a constitutional right is.
Anyone else at this table? We'll move to this table. Anyone here?
I've just been reading a little bit recently. I think National Review had a piece not long after the Parkland tragedy about the gun violence restraining orders, and I'm sort of new to learning about these. I know they've been around for a while. Just curious your views on those.
Well, it's already a crime under federal law and the law of many states to possess a gun if you're under a restraining order in a domestic case where you've had an opportunity to be heard, an opportunity to have counsel present. So you've got due process invoked there, so that's fair. That's considered fair. It's not considered fair if somebody can just go out and denounce you and they seize your guns and you have no opportunity to be heard, even in an emergency situation. So it depends on how they're drafted, I think. There's some newer laws that have to do with relatives bringing to the attention of law enforcement if a person seems to be a danger to self or others. And I don't think there's anything wrong with that if you maintain due process with it. But you can't just go out and do it and you know, shoot them all and let God figure it out later in terms of rights. So that's my response.
Okay, thank you.
Anyone else, Ms. David? Anyone here?
What do you do if you're not at the table?
We'll get to you. It's okay.
You know, in the latest Waffle House shooting, there was a situation where the person's weapons were taken from him because he was deemed a danger. Those weapons were then turned over to his father, who apparently gave those weapons back to him. Do you have any thoughts about that?
Yeah, you know, I don't know all the facts. I know this guy had a Ford card in Illinois. That's a firearm owner identification card. And it was taken from him because he must have been a mental problem and he was considered a danger. And so I think it's correct to let other people, relatives, take the property of somebody who can't possess it as long as they don't allow access to that person. And so depending on what the actual status of that fellow was, whether his father, when he transferred the guns back to him, that might have been a federal felony. But I don't know exactly all the facts, and so I can't say for sure. But it was really something stupid to do, and it's something that in many contexts would be a federal crime.
Anyone here?
Bar host. Sorry if I can get up at my age. Yes, thank you. What a gentleman.
No problem. Okay?
Okay, just a quick thing before, so you know what this present is for you. Oh, just a quick thing to let you know why I'm here and bringing you this present. Okay. It's my second one. I thought I could. He won't carry it in RA. Okay, thank you. Okay, real quick. Okay, my name is Alice F. Labrie, courtesy of Louisiana. I'm a Creole. I live on the Harlem River West Bank. I am former U.S. Department of State Foreign Service, Turkey, Oman, Sweden, U.S. Mission UN under Richard Holbrooke. I'm a Republican in Harlem. I'm NRA, both things I'm nervous to say in Harlem. And I'm pushing for a militia in my development in case my 32nd precinct is overwhelmed in case of a terror attack and they're taken from us. I'm also asking for a militia because I'm afraid of the active shooter in my esplanade. So here, I got this free thing for donating, the second one from the NRA. Wayne gave me this. Sorry.
Wow.
To keep you warm at night beside your wife.
Thank you, ma'am. Thank you very much.
And last but not least, my actual question, what happened to Haley Barbour, my candidate for office always? He got busted with the loaded gun.
I don't know the answer to that. But thank you for your comments. And this whole idea of a citizens militia, that's really what our country's founded on. And it has to do with self-help, people looking out for each other, neighbors. And it's something our country's really gotten away from, and the emphasis is on, well, that's a job for law enforcement. But, you know, when seconds count, law enforcement is just minutes away. So it's something that, especially in crime-ridden communities, that having law-abiding people there who are armed and not having them harassed by local laws You know, how many gun permits are given out in this in New York, in the city especially, and all the favoritism and discrimination that exists. So, thank you for your comment.
Thank you very much, Professor Halbrook, for all the work that you do and for coming here to speak today. And my question, well, I have two, but I'll ask one. My question is how much of the bad policy that's made, the muzzle brakes, the 7-round magazines, the, famous interview with the Congresswoman misidentifying a telescoping stock and a flash suppressor, is a result of ignorance on the part of, a large part of our country and our policymakers on the subject, and how much of it is a result of an active desire to suppress the ability of law-abiding people to defend themselves and potentially to defend against, in extremis scenarios, meaningful government oppression and overreach?
Well, that's a good question, and I think I don't doubt the sincerity of many people, of whatever side of this issue they take. Many people are very sincere, but I think there's definitely a deficit in knowledge about what we're talking about. Anybody who thinks it's a panacea for crime and violence to pass more laws that affect law-abiding people just doesn't get it. But there are many sincere people who think that, and they don't know about what they're talking. Just use another example similar to that. There was the Colorado legislator who thought that magazines are expended when you shoot the gun. And so all the magazines are eventually going to run out. So you don't have to worry about it. I mean, you can ban them, and then if you grandfather them, it's okay because they won't exist anymore after a while. But on the other hand, throughout history, you've always had power elites do not want people that can resist manipulation. And we have this social engineer mentality in this country, and it's been around always. It goes back to ancient times. Do you have an elite ruling and everybody, and you have specialized bodies of armed men, police and military, to enforce their power because they know what's best for everybody else, and you disarm those at the bottom, the stupid workers? Or do you have a polity or a republic where power is spread out, and you have, the ballot box and the jury box and the cartridge box? Those are powers in the people. That's what those are. They're not just rights in the people, they're powers in the people. The 10th Amendment refers to powers reserved to the states respectively or to the people. So people have powers as well as governmental bodies having powers. And the Second Amendment really is both a right and a power.
Now, the SAFE Act included a number of ammunition provisions, and I know that part of them haven't been enacted, and I know that Judge Scretany in the district court said that the claims weren't constitutionally ripe. Now that it's been the law for a few years and we're seeing a number of these provisions take place in California, do you think there's any future to ammunition challenges under the Second Amendment?
Well, there's challenges now that are pending. The green state of Vermont just banned magazines that hold more than 10 if they're for a rifle. There's an interesting history of Ethan and Ira Allen, who founded Vermont. They hated the Yorkers because New York was always trying to intrude upon them. And they carried guns everywhere they went. But now there's a challenge to that magazine ban that was just filed. In California, California has had a ban on magazines that hold more than 10 for a long time, but they grandfathered those that were lawfully possessed before the laws were enacted. But they now have a new law that just went into effect that and there's millions of these magazines in California, millions of them that hold more than 10 rounds. All of them are illegal now. I think January 1 was the date. But there's a district court judge who enjoined the enforcement of that law, and it's pending in the Ninth Circuit. Well, the law will probably be upheld. That's the Ninth Circuit. And on the other hand, so we've got millions of these magazines out there, and not one has been turned into law enforcement in the state of California. And so what are you trying to do? Just breed people not respecting the law? That's what's happening with these laws. So there's ways to get in compliance with some of the laws. Like New York, you've got the weird stock that you can replace your pistol grip with. You still have the same gun, or you can go store it in Vermont or some other adjoining state. But you know that these laws aren't proving anything.
Thanks for being here. During her confirmation, Justice Sotomayor, confirmation hearings, Justice Sotomayor was asked if the Second Amendment was applied to the states, and she answered pretty much she wasn't sure if the Second Amendment was incorporated to the states, was the word she used. I always thought that ratification solved that once a state ratified the Constitution, it was under the Constitution. However, I'm just wondering if there is any thought about this matter of incorporation to the states.
By the way, I testified in her nomination hearing, and she had joined in some opinions that were very adverse to the Second Amendment when she was on the Second Circuit. But and one of those upheld the prohibition in New York State on nunchucks, 2 sticks connected by a cord. But in the hearings, they were like saying how great she was because she saved baseball. There was some dispute. I don't remember the details, but so the games could be played, some dispute with management or unions, I don't know what. And so I started my testimony by recalling the incident where Al Capone used a baseball bat to take care of a couple of problems. But it's like, you know, you're going to uphold a ban on these 2 little sticks connected by a cord, but baseball's okay. But she did say she would respect the Heller decision, and I think that might have been before the McDonald decision had been decided, saying that Second Amendment was incorporated. I don't remember the exact year now, but you know, future justices say things, and like I'll respect that, but then they vote a certain way, and so just like.
Some people think that maybe the Second Amendment applies to the federal government and not the states. I think that's what she was trying to say.
Right, right, because there were judicial decisions saying that, because the Supreme Court had never explicitly held that the Second Amendment does apply to the states until McDonald in 2010, and so. That was another thing the Supreme Court left unclear for decade after decade, and it was finally resolved at that point.
Hello, Mr. Halbrook. Thanks for coming tonight. I believe you had alluded to it in the 1968 gun ban. Just because I was a person who grew up going to school in the 90s, where it was drummed in my head and I knew it was wrong about the well-regulated militia theory. What would be the best defense to support that the well-regulated militia is just a group of citizens defending themselves, not the military, which tries to get spun, in my opinion. So.
Well, I mean, the historical evidence is clear that the original colonies and then original independent states required all able-bodied males to be in the militia in certain age groups, and they required them. Right. That was not part of the Army that could be raised, which is a separate part of the Constitution. But every state law had a militia clause, and you were required, if you were infantry militia, to have a long gun, a musket, or a fusee, or a firelock. If you were on horseback, you were required to have a pair of pistols and saber. And the muskets had to be equipped with a bayonet. So here you have an actual military implement, a real military feature, and not only was it not banned, it was required. And so to say that some kind of military feature makes it bannable is completely the opposite of what the Second Amendment originally stood for. The only purpose of a bayonet is to kill as many people as quickly as possible if they're invading your country or if there's a domestic insurrection. But now we have the U.S. Court of Appeals for the Fourth Circuit recently upholding a Maryland so-called assault weapon ban, saying that there's no real difference between semi-automatic, which requires a separate trigger pull for every shot, and full automatic machine guns, which you hold the trigger down and it keeps firing. It's only a slight difference, the court said, and to uphold the Maryland ban. So there's a lot of slipshod factual and legal statements being made. I mean, that's always been quite a legal distinction between a full automatic and a gun that requires a separate pull of the trigger. I mean, it means the difference between the penitentiary and nothing. If you have an unregistered machine gun, that gets you 10 years. If it requires a separate pull of the trigger in most states, it doesn't get you anything. And so you've got judges can say anything they want, and they say the most crazy things sometimes, factually and legally, to uphold these kinds of laws.
Chris Garvey, I'm the Libertarian candidate for Attorney General and a member of the Huntington Militia, and we've been drilling since 1653 on the Huntington Green. Are you aware that there's still a federal statute defining the unorganized militia as all able-bodied males between 18 and 45 who are not in the organized militia or the military? And how did or would that affect your arguments in court?
Well, that's a federal law that you're correct, it's still on the books. The original Militia Act of 1792 said every able-bodied male has to provide their own guns, but it also had the word white. After the Civil War and after the 14th Amendment was adopted, that word white was taken out, and so African Americans and anyone of any other race or complexion or color or whatever was considered in the militia, and it was required to provide their guns in the militia. But that faded away, and by the early 20th century, it was no longer required because it had never been enforced, at least for a long time. And then you have the enactment of the law that you just mentioned, I think in 1903 or so, that they still defined all able-bodied males as being part of the unorganized militia or reserve militia, and that's still in the books today.
Yeah, a couple years back, my then Congresswoman Carolyn McCarthy, who was a big fan of all things gun control, appeared on Tucker Carlson, and he interrogated her about banning a barrel shroud. And of course, she had I think she thought it was a religious artifact.
Yeah.
But could you explain to us what makes a barrel shroud so sinister? And then if I could just ask a quick follow-up, what are the pros and cons on banning bump stocks?
So the barrel shroud is another one of those evil, wicked, mean, and nasty things that makes something so deadly, it's so incredible that it should be banned. That's on your features list in New York State. If a semi-auto rifle has a barrel shroud. Well, hello people, a barrel shroud is nothing but a hand guard. It can be in many different forms, and it's so that you don't burn your hand. When you fire a shot, it creates heat. And so if you fire more than one shot, it gets hotter and hotter. And that's the case no matter what the action. It could be a bolt action and it would still get hot. And that's why you have, it could be a traditional wood handle, or it could be something that goes all the way around the barrel. And so that's another one of those things that, well, it really doesn't hurt anybody, but why don't we put that on the list, because somebody who doesn't know anything about guns thought about it. So.
And on the bump stocks, so-called bump stock?
That's something I don't know of any record that anyone's ever misused, and then of course one was horribly misused, or several were, in the Las Vegas attacks. And the question is whether they are considered machine guns. The ATF in the past has gone different ways on different kinds of devices like that. And now there's a pending rulemaking to say that they're machine guns. And I would just say this about it: the ATF cannot change the criminal law. So either a bump stock's a machine gun or not. And if they adopt that regulation saying that it is, that would be considered an advisory regulation about what ATF interprets. And in a criminal case, I don't think it'd be proper to allow that to be stated, because that's a legal conclusion about what a device is. And Congress makes the law. Congress defines what a machine gun is. And so a jury instruction would be to just state what Congress has said in that definition, if there was a case of an unregistered machine gun. So we'll see what happens with that issue.
Can we please have a big thank you for Professor Stephen Halbrook?
Thank you. Thanks for having me.